Hello, everyone, and welcome to another episode of U.S. Law Live, the podcast. I am Jessica Dark, one of your co-hosts. I'm out of Oklahoma City with the law firm of Pierce, Couch, Hendrickson, Basinger, and Green. And I am joined by one of my most esteemed colleagues and co-hosts, Miss Pam Halford. Pam, how are you?
I'm doing good, Jessica. Bracing for some unseasonable, unusual weather. Um, I am with Carr Allison, one of the only Alabama firms, one of the Florida firms, and one of the Mississippi firms. And our area is going to get some winter weather, which is unusual for us this week.
Well, same for here in Oklahoma and apparently the Midwest, but that's actually a great segue to introduce our guests today. We are joined by not one, but two fabulous U.S. law attorneys. We have Dan Gerber and John Jablonski from Gerber Ciano in New York. Hello, guys. How are you?
Hi, how you doing? I think we might get the corner on the weather being in upstate New York. We've been receiving it and look to receive more.
I like to think
So
that you guys are a little more prepared for such winter weather. Our stores have been ransacked. There is nary a water bottle in sight. What's going on up there?
We get a foot of snow, we wake up, we go to work. We get 3 feet of snow, we take the day off and go to work the next day. But that's upstate New York.
I
I
will
think we're
say
going to get 3 centimeters and the entire town is shut down.
yes, all of our courthouses are closing at either 11 or noon today. Schools are out, offices are closed. It is a full-on apocalypse, and not a drop of precipitation has occurred. So, what are your thoughts on that, John?
Well, thanks. And what's funny is my wife had to go out to run some errands, and we have about 8 inches of snow in the driveway. And she's saying, I don't think I need to clear the snow. I'm just going to go out. And sure enough, she called me. She said, I got out, no problem. The streets are clear. And she went to the store. And another, since the Buffalo Bills seem to be in the headlines lately, interesting fun fact is our old stadium, which just had its final season, they would bring fans in at $20 an hour to shovel out the whole stadium so that they could have the game. So we weather the storm, as you will, in Buffalo, New York, as best as anybody in the country. And as Dan said earlier, it's just another day. Depending on the volume of snow, everyone just goes about their business.
Yeah, you're just built different, I think. Well, tell us a little bit, John, about you, about your practice, about Gerber Ciano. I know you guys are fairly new to the U.S. Law Network. We're so glad to have you. Give us a rundown.
Yeah, so I'll start with the firm at a very high level. So a group of six of us left a larger firm that actually was a U.S. law firm for a period of time 8 years ago and formed our firm. And over the last 8 years, we've grown from six attorneys to 80 attorneys in that time frame.
Oh my gosh, that is impressive.
Um,
Yeah.
I know, I appreciate that. It's been fun. Obviously, it's a lot of work, but we very much enjoy it. We have really worked very hard to create a excellent environment for our team members, the lawyers, and all the people that support them to work in support of providing excellent client service for our clients. And so we were fortunate starting recently. We have high commitment to technology, went all in on the cloud before other law firms were going in on the cloud, which actually helped us during the pandemic because we were already cloud-based and allowed us to start, and I'm sure we'll get into it some today, started working on some early adoption of AI and using technology to the benefit of our clients, which is actually a nice dovetail into my practice. One of the principal things that I do is help clients negotiate technology contracts with large providers, Google, Microsoft, and others, where we negotiate the terms that our client is going to use. That also then translates into advising clients at the C-suite level on data security and privacy policies, procedures, disaster recovery, things like that. I got heavily involved in technology issues, over 25 years ago. Built a lot of my own computers during law school. And then I'm old enough, although your listeners can't see how young I look, but I'm old enough to remember when we used typewriters during the practice of law. And so some of my early research as a young associate at a very large firm with over 600 lawyers was, are emails containing attorney-client privilege material actually privileged? There were.
Wow.
That's how old I am. Yep. So there were.
Did they have color TV back then, John?
Yeah, but they did actually. I'm old enough again to remember black and white TV. So, on the big antenna on the back of the house, because we're on the border of Canada. So my dad prided himself on being able to get all 4 Canadian channels. So that was my childhood. So, you think back, there was ethics opinions. Was it like a phone call? Was it like correspondence? And at the end of the day, everyone landed on an email is privileged, which then led into the e-discovery industry. And so in large cases where we have to sift through hundreds of thousands of documents to identify communications that are attorney-client privileged. And so that led me to do early e-discovery work before anyone knew it was e-discovery work, along with all the technology consulting that I was doing. I actually wrote a book in 2009 called Seven Reasonable Steps for Legal Holds of ESI and Other Documents. We updated that 2 years ago to bring it current, and it's on Amazon. But it helps clients go through the whole preservation process. We undertook to explain in English. I know Dan is a big proponent of this, but I'm also a big proponent of this, the why of why you're doing things. We all send our clients emails or letters that say, hey, you have a duty and obligation to preserve evidence. And clients are like, what are you talking about? And what do you mean? And then you're interviewing witnesses as part of the legal hold process and talking to them about the same thing. And few folks take the time to explain the why. And you explain why it's important to preserve evidence, why our judicial system views not preserving evidence as a bad thing, like flushing evidence down the toilet when the cops are outside, and then the plaintiff's bar turns that into spoliation motion in the courtroom. And so, an ounce of prevention versus a pound of cure goes a long way in the preservation and setting up litigation hold policies and procedures, information governance at a company. And with the proliferation of databases and now AI tools, it's really important. And a lot of clients are just throw their arms in the air when it comes to preservation and preservation obligations. And that also extends to saving money in litigation, which all of our clients love to do, by making sure that you have a reasonable, defensible litigation hold process. And I will stop going down the nerd rabbit hole right now and pull back and say that we're heavily involved in some complex litigation at the firm across all matters of types of cases. And we're very schooled in protecting our clients' interests and helping them in the preservation process, which in turn keeps costs down in the litigation. I also do some transportation litigation, as well as consulting at the C-suite level for some transportation companies on some of the things that we talked about. I do some commercial litigation, contract breaches. I also do data security and incident response. So we have a group that does responses to data breach circumstances, reporting to individuals across the country and state attorney generals and credit bureaus, and doing all of that. That is an emergency response often, much like some of the other areas that we may talk about at the firm. So we're very good at doing that. And I think that should be good for a brief introduction. I tried to be brief.
Honestly, that's super impressive. You have a very, very, thought-provoking experience and knowledge. And I'm just thinking, of course, for me selfishly, what is kind of one issue that you see attorneys or law firms either not prepared for or maybe don't handle well, that if you could give a free tip, what would you say is something that needs to be kind of paid attention to more on the law firm level?
Yeah, so on the both for the client side and for the law firm level, I think from a preservation standpoint, and then even from a data security standpoint, is taking the issue seriously. And if you're out of your comfort zone, get an expert, get someone who knows what they're doing. Don't put it to the back of your desk and I'll get to that tomorrow.
Hope it resolves on its own.
Well, in both instances, time is really of the essence, right? I was involved in a case where the client had a 1-day document retention policy for emails. It was very advanced. And they waited 2 days to issue a litigation hold, and there was a spoliation sanction against them because they didn't implement their legal hold fast enough, simply because they had such a aggressive retention schedule. And the same thing on the data security side. People, especially, and this will be to lawyers that are listening, you notice something wonky in your email, you may have clicked on something and see strange lights going off, or something happens, report it to your technology team, report it to management immediately, even if you aren't really sure. I've seen over the years that a lot of attorneys will kind of cross their fingers and say, well, I can still finish the brief I'm writing because the cursor's only moving around occasionally, not all the time. So I can finish my work. So I think it's really important. And then bouncing back to the client side, like for preservation issues, it does take some work in advance to investigate the scope of preservation, where data is stored at your company, how to preserve that data at the company, and then collect it for production, and coming up with a strategy. Often in the discovery process, that gets swept behind, especially if a lawyer is not technologically advanced and doesn't bring someone onto the team that can help them. And then it just compounds, and then an error happens and it doesn't get reported to the judge. And the next thing you know, a letter's going to the Bar Association about why you shouldn't practice law. So not to be dramatic, but we've seen it happen outside of our firm, and they're easily preventable issues.
Yeah, no, that's a really good point. And it's something I brought up with an associate the other day. He came to me and was just like, oh no, we messed up. We didn't sign the certificate of service on the discovery requests. And I was like, oh, buddy, no, totally fine. Not a big deal. I was like, but this coming to me immediately after realizing something wasn't done exactly right, perfect. That's exactly how we need to handle everything, whether it's very small or oh, I accidentally clicked on a ransomware ad. Let's attack it as soon as possible. So I appreciate that. And now let's kick it over to Dan Gerber. I'm assuming this is Gerber of Gerber Ciano. Wow. Tell us about how you've gotten to where you are, Dan.
Sure. My own practice is primarily in the insurance sphere. Anything that comes around structure of insurance companies, setup, acquisition of risk, M&A work around insurance, regulatory. My background traditionally was as a litigator. And so I've litigated a lot of insurance and reinsurance disputes. I still do, but I kind of took that to then working on the transactional side, which I think brings a unique perspective, having the litigation background and then bringing the transactional piece. Not everybody does that. The firm itself has a sizable insurance solutions practice, which basically exists for anyone in the insurance space for its purposes, from coverage to reinsurance to all the things I just described. So we have around 20 lawyers who are just in that practice. So in addition to our other practice areas, which is traditional insurance defense, professional liability, retail, transportation, you name it. We have a sizable products practice. But what is kind of fun, or I think I'm fun, I'm not fun. I have fun doing, I should say, and it's a bit nerdy, is building things from insurance. So I get to participate in this side that goes out and finds risk, builds a new risk vehicle, decides where it's going to write. I do a lot in the acquisition of existing liabilities. So where either insurer or quasi insurance like vehicles are acquiring existing corporate liabilities and taking them off corporations' books, or reinsuring another insurer to take years of policies off of their books, like from dollar one, and relieve the capital. And where that positions the firm, often in a nice, client development phase, and also working very closely in partnership with clients on what they want to achieve from kind of day one, is we will work on those transactions, structure them, and then look to see them through to even kind of managing the acquisition of the liabilities post-acquisition. So we don't necessarily always take over and step in for every firm handling the litigation risks or liabilities around the country or world, wherever they are. But because we know what the acquirer wants to get out of the book, we can add that layer of working with those existing firms. Or in certain instances, we do step in and add value or partner with existing firms, or just need and serve as national coordinating counsel as a result of these transactions. So it's kind of a niche area, but it's something that I have a lot of fun with. And then because of that kind of specialty, I've ended up doing a lot of expert work, testifying in federal and state courts around the country in various matters about insurance, and how it's construed, what bad faith is, how policies are structured, and how reinsurance works. And then I'm sometimes asked to do that internationally as well, when oftentimes another jurisdiction needs a opinion on how it works in the U.S. And so I've done a lot of that.
Wow. That's fascinating, and I'm so impressed with the growth that you all have experienced so quickly. I imagine that was exciting and also very challenging to manage, making sure that the ship stayed upright. So congratulations to
Thanks.
you. Before we got going, we were talking a little bit about what's going on in New York with respect to RICO and these plaintiffs' firms, and I'd love to hear a little bit more, and I'm sure our audience would too, if you guys don't mind.
Sure. So there's been a lot out there in the news about one particular insurer or MGA here in New York filing and pursuing a number of RICO claims against doctors and plaintiffs' lawyers for fraud. And of course, with RICO charges come everything, or RICO civil complaints come everything from attorney's fees and punitive damages. So there is a lot at stake. And what it's led to is certain doctors agreeing not to testify in the future. It has, as recently as last week, led to a pretty significant New York City-based plaintiffs firm just closing their door and going out of business, and their 1,000 or so cases not having a home. What you see when you peel a lot of this back, and it's the first time in New York, at least, we've really seen a concerted effort by an insurer to get the receipts and then pursue it against what is a strong plaintiffs bar, in New York. The receipts I'm talking about are things such as, having a alleged injured construction worker who then, has a scan of the back, certain injuries to the spine, and then that same person arrives with a different name on the next claim. And that doctor could be reviewing the same, results. And it kind of just ends up being exactly what fraud is, fabrication. But it was, often thought of as happening, but not really pursued. And although these actual objective things are happening with doctors and certain firms, the courts are struggling a bit because the cases still exist. Or, a plaintiff might go to the new firm and the courts are trying to decide, okay, we know this happened with this doctor. Should I preclude all testimony from a certain doctor in this case or other doctors? Just because this case was one that was at the firm that closed its doors, does that mean all of them are bad? And that is working its way, through the system and the courts right now. There's many of those types of matters up to our intermediate appellate courts that are weighing in, but it's really front of mind of everybody litigating in the defense space in New York, especially because New York has a unique statute called New York labor law, which has nothing to do with what you think it would, which is you'd think labor law, it's the employment of people, but it actually has to do with imposing strict liability on general contractors and contractors for construction site losses at an elevated height. It's basically also referred to as New York Scaffolding Law. And these cases have to be defended in a very unique way. The plaintiff's bar gravitates to them as opposed to, in other states, it might be more asbestos or, there's still asbestos here, but other types of niche cases. Labor law in New York is a big win because you start off with, if you can establish a fall from a height, you have summary judgment against the GC and the owner. And so we end up with tons of these cases, and they have been ripe target for some of these, the fraud area as well.
Was this sort of like an unspoken, I mean, everybody knew it was happening, but nobody knew what to do or how to do it?
There was a lot for years where, people would just, see a lot of what they thought was manufactured, and you would pursue it claim by claim, right? And really try to deal with it with a certain doctor on cross-examination or, see if you can't have somebody follow a plaintiff to their IME, independent medical exam in one case, and then, go to the next one and then actually put those videos together and say, that's the same person. We've had that happen before.
Right.
But this is, the first real presence in New York by somebody pursuing it in a concerted effort and getting results. And again, I am not tied into the criminal law side of things in New York. You just hear the whispers, but it'd be my general understanding that there are, authorities involved in looking at a lot of this as well.
You mentioned kind of concerted efforts. Are you seeing a lot of coordination among defense counsel and among clients and defendants, kind of, let's help each other out? I know that at least in Oklahoma, our plaintiffs bar is a lot more organized and sharing ideas and plans of action than I feel like our defense bar is. And I think we could benefit from that. Is that something that you're seeing or participating in?
So the defense bar has some, New York organizations that work well together, and there's various discussion on it and how to deal with it. And one of our partners is actually the chair of the appellate group of that organization, and he has submitted several amicus briefs on just these types of RICO actions on behalf of that group. And so there is more concerted effort than in the past, but it really took the one managing general agent tradesman to kind of come in. Their name is known, so not speaking out of school, everybody kind of knows it's them, to pursue this and bring it forward and be serious about it. There were many other carriers or people in the industry that probably could have done it over the years, but they've stepped forward and really have pressed it and gotten objective results.
Well, and I would just add that the reality over the years has been you're facing these issues on a case-by-case basis. And if you are asking the judge to do discovery on what appear to be fraud issues, and you just have a hunch because we have been practicing law for 20, 30 years, and you're like, this just something doesn't smell right about this case. The judges aren't always as convinced as the defense bar or the client might be that there was some fraud going on. And so that's a bit of the testing and issues that Dan is mentioning about trying to work this out through the court system. Now, what evidence can come in a case, and what will the judge allow that won't prejudice the plaintiff? And they're trying to balance that issue versus giving the plaintiff his day or her day in court. And the plaintiff's bar is very good at talking about how the defense is just making these things up.
Yeah, I think it's really interesting. So I practice primarily in the transportation space, and we see these types of issues, all over left and right. And I just always find it so fascinating. It's difficult for me to believe that a person would, maybe on advice of counsel, go and get some medical care that was not implicated by any sort of objective test or independent doctor recommendation. It's unfathomable to me. And so I mean, every time I'm presented with the issue, it's hard for me to wrap my brain around. And I mean, I deal with it every day. And so I think about our average juror, and I'm like, how the heck are they supposed to believe this when I have a hard time and I see it every day? So I really think it's so important for our judiciary to get involved and have these opinions so that we have another path before saying to the jury, hey, listen, this is totally bogus. Because I just think it's really hard for the average person who doesn't deal with litigation every day to believe that a person in their right mind would go and do that. But that's what's happening.
You're absolutely right. And then a lot of it transitions over to legal funding efforts and where the money is coming from, and actually where some of the, as alleged in some of these RICO complaints, where the money is ultimately going. So
Yeah.
Some of these legal funders have been set up, in the same offices as some of the firms that the complaints
Yep.
are alleged against. And then, without going too far down a rabbit hole, where that money comes, be it foreign or criminal, is often sometimes subject to question. And so what will truly end up in a plaintiff's pocket, who might make some money to help their family and themselves if they have a surgery they don't need, versus what the real award was and where that money went, is subject to question in a lot of this.
Well, and I would just add on the litigation funding side, I think this is a call to any other lawyers that are listening, whether or not they're in the U.S. Law Network, is I think the defense side needs to continue to focus on litigation funding and ways to bring litigation funding into the courtroom to identify motivation or malingering, or why a plaintiff won't resolve a case, because there's pressures, as Dan just mentioned, pressures on the plaintiff beyond just I'm injured and I need to be made whole again. Because to make the plaintiff whole in a fair way, it may mean putting money in 2, 3, 4, 5 other pockets, mostly driven by the litigation funding. And so, in my career personally, we've seen higher demands, cases settling further into trial versus before trial, even though a mediator, a judge, both the plaintiff and the defense attorneys seem to agree on what the cost of the claim is based on similar cases in the past, but we can't get a plaintiff to yes because the plaintiff is facing the specter of paying the litigation funders back. And then in the way many of these agreements are structured, if the plaintiff goes to trial and loses, whatever funds were put in the plaintiff's pocket, he gets to keep. He doesn't have to pay. He or she doesn't have to pay that back. So it's really putting a lot of pressure on the judiciary, but yet at the same time, the judiciary is looking at these litigation funds as how does it it kind of goes back to the fraud that we were talking about. How does it come into my courtroom? How is it relevant to my case? We view it as very relevant, but it's from the plaintiff's bar, it's no more relevant than whether or not the person has insurance to cover their medical damages. And so that is really the new frontier from my perspective. There's not a lot of research around the country and not a lot of success in New York getting facts into evidence that show that litigation funding is in place, and that may be a motivation for a plaintiff to not return to work or to exaggerate injuries.
Well, John, if that's your pet project, we won't keep you any longer because you've got a lot of work to do. And since our conversation trended so positive, I think we all deserve a lunchtime cocktail.
Sounds good.
I appreciate you guys being here. I know Jessica does as well. And we are so thrilled that you would allow us to spend some time with you and let the network get to know you a little bit better. And we appreciate your time today. Thanks, everybody.
Thank you. We appreciate your time and the networks.
Yes, I would echo that. Thanks for everyone's time and for everyone that's taking a moment to listen. And if you made it to the end, thank you for listening to us. We really appreciate it.
Thanks again for joining another episode of US Law Live. Join us next week for some other great guests.